Any mention?
This courtroom has become too small, I think.
Please, Your Lordship. Your Lordship, I beg to mention item number 19 of the daily cost list.
19?
Yes, Your Lordship.
How's your senior?
Your Lordship, in and out of the hospital, Your Lordship. Still has tests to run. Your Lordship, I beg 3 weeks' time.
Fractured his foot.
Your Lordship.
How much time?
3 weeks' time, Your Lordship. Highly obliged, Your Lordship.
He's relieved.
No, there's a stay order. It's in my
3 weeks and request as a senior counsel for respondents is indisposed. Interim order of any shall continue until further order says.
Highly obliged.
Much obliged.
Lordship, I beg to mention item 23.
20?
23, Your Lordship.
No objection, Your Lordship.
Very quick. Why?
Your Lordship, Mr. Paul is having some personal engagements, so he won't be available.
2 weeks. 21 matter, yes.
Highly obliged.
Please, Your Lordship, I beg to mention item number 31.
31.
Yes, Lordship.
31, Livingstone Rambai.
Yes, sir.
On behalf of?
The London Consul, Mr. J. Sheila, is currently out of station. Therefore, I prefer 2 weeks.
After?
2 weeks, Your Lordship.
2 weeks, yes. Your name?
L.N. Aring.
L.N. Areng.
Yes, Lordship.
Do note down his name. L.N. Areng Vice. To do personal difficulty, yes. Yes.
Lordship, item 32 is a joint request made out for an adjournment for a week or 2 months.
So joint request means automatic adjournment.
Both the seniors are having some difficulty.
Court not having difficulty. Court can look at the file and decide. Yes. After how long?
2 weeks.
2 weeks, yes.
Supplementary list, item number 1.
What is this, Mr.
Wait, please, Your Lordship.
Madam?
Agree because they have not disposed the representation now for more than 6 months. Your Lordship.
Which representation?
Annexure 4, Your Lordship.
Representation regarding?
Regarding the just a clarification as far as the
rental of land.
yes. No, nothing to do with that, Your Lordship. The only the issue in this
Copy joint representation.
let me rephrase, Your Lordship. The very limited
Prayer.
for direct the respondents to dispose of my
No,
representation.
what is the
Let me
point
come
in
to that.
issue?
It's very simple, Your Lordship. This area is being declared as a land custom station area.
Where is this area?
It's in Shala Bazaar.
Okay.
That's it. But despite of that, prior to that, it's been before declared and notified. The landowners have already approached the respondents that they will give the land free of cost.
Respondent means?
I mean the customs.
Okay.
Because it falls under the jurisdiction of the custom. Simple like that.
Okay.
But despite of that, the landowners, Your Lordship, they're demanding, they're charging hefty amount.
I mean the landowners who give the land free to the customers.
Yeah, to
Now
the
they're charging, what they're charging from you?
I do. That's all we were agreed. Because of that, we want to get a clarification for that.
There is no clarity in this representation also, my lord. Lordship, kindly see page 16, my lord.
No, where's the copy joint representation? Includes hearing.
It's there 16.
No, 16 is your copy is annexed. Where's the copy?
Yes, Your
You
Lordship.
see, regards, we would like to get clarification as to why landowners, after they've given land free via gift,
Been declared and notified. Yeah.
why would you charging a hefty amount up to 1 lakh annually from exporters for exporting limestone,
Yes.
which illegal since the land has been gifted free of cost? Thanking you, copy joint representation of landowners and title suit number so and so. What is this? Where is the joint representation? You have it with you, a copy.
Yes, Your Lordship.
You have a copy of this one referred here in the enclosure.
No, I have not appended, Your Lordship. I have not appended.
Why?
Sorry.
You have a copy.
Right? I don't have, but right now, in the next date, I will file it, Your Honor, by way of affidavit also.
Otherwise, one thing you do,
Just to get a clarification
Mr. Wallang.
whether the owners.
I think you better recast the petition.
Yes.
We'll give you liberty to withdraw if you want to recast. Otherwise, as it stands now, I mean, I don't see any
No, I
relief will be forthcoming. You can withdraw and file it tomorrow.
With your permission, because I'm not asking about the merit of the case.
No.
Yes.
Even to make it, I mean, coherent. That's all.
No,
That's the only thing, to make the petition coherent, and you withdraw it. We will give you liberty. You file afresh. Just annex the other joint representation, whatever.
But whatever that order passed from the district council also.
Whatever he has required documents.
Yes.
Mr. S. Wallang submitted due to some deficiencies. He may be able to withdraw the petition with liberty to file afresh. Matters close to withdrawal, with liberty as paid is.
Sorry for making inconvenience, Your Lordship.
No convenience. The court's always open. Everybody is.
No.
When a person comes to court, the court has to ask a person, what is his problem? Yeah.
Main list, item number 1.
Yes. Where's Miss 4 and 5, Mr. B. Kriam?
I'm praying for respondent number 3.
Where was you been?
Yes, out of station, Your Lordship.
Mr. Kanta is ill.
Yes.
Mr. You was out of station. Mr. B. Kriam? He's available today. Mr. Shati? Missing in action. What to do? We have done it because the Council of District Council, Mr. Vijay Kinta said he's sick. They're not mentioning his behalf also, only that in the division bench that he's sick.
Lordship, may kindly let this matter come after 1 week, Lordship, next week.
Yes, no, that time because Mr. Kriam was not present, that's why we were going to actually dispose of this matter. But because of absence, we stopped short. What to do?
After 2 weeks since the Senate is in terms of keeping well.
Less matter of 2 weeks as the council for respondent number 3 is out of station and council 1 and 2 is indisposed. None appears for number 6. Mr. B. Kiran present on for 4 and 5 is.
Item number 2.
Your Lordship, I pray that this matter may be taken at the end of the board. Both Mr. Bhattacharjee and Ms. Kolni are on legs.
Status report. How's the situation now? It's okay?
It's okay now. No problem.
Then otherwise we can close it today. Let the investigator take its call. Provided that let's see the last status report. That's all.
Obliged, Your Lordship.
3.
Yes.
May please, Your Lordship.
Ready?
This is the arbitration matter, my lord.
Right.
Synopsis is about to be finalized. If this can be taken on Monday, my lord, we'll be highly obliged.
Same problem with us, my lord.
What's the problem?
We prepared it, my lord. It's in the
After 1 week, yes.
Highly obliged.
Very interesting point.
4.
That's why I asked for bullet points. It's not 1 week to enable the parties to submit their synopsis and bullet points. Right.
The pleading are complete here, Lordship. We will not file rejoinder.
Mr. D. Nyota submits that no rejoinder before coming, and that the pleadings are complete. Accordingly, it's a matter for hearing usual cause.
Yes, Your Lordship. Obliged, Your Lordship.
5.
My lord, nothing survived. The trial court has dismissed the miscellaneous application filed by my friend. Motion can see the order.
We are just order hasn't passed. We just would like to, my lord, bring this order and SOCOS filed by the respondent. By your affidavit. My lord, I'm just bringing, my lord, may have it kindly tomorrow, Lordship.
No, Mr. Panthi, the thing is that We only, the only intervention was that they said, okay, fine, the matter 6 for hearing injunction application is filed, you have other remedy. We won't, why should we prolong it? Let's see the order.
Madam, I have flagged it, my lord. Para 78.
What is it, Mr. Sen? Anything survive?
Nothing survived.
Because the only thing is for, yes. Regarding that connection?
Lordship,
what other orders do you expect from this court when you are the petitioner, right?
Lordship.
Yes, let's see what was your prayer. Number 227, Mr. Panthi.
Page number 18.
Yes.
Page number 18. He is challenging the impugned order. Page number 268.
Nothing survives now.
Nothing survived.
You take your chances.
But can you have it, Lordship? I'm just praying, can you have it tomorrow, Lordship?
Why tomorrow?
Tomorrow.
I think the events will change from now in the next 24 hours.
That we cannot, Lordship, but Ahmad submission, but can you just take up tomorrow, Lordship?
You need some instructions.
Lordship.
Okay, this is matter tomorrow. Yes. On the prayer of? No. On the prayer of Mr. S. Panthi. Yes. No affidavit in civil revision. Yes. Okay.
6.
Okay.
Well, we are taking steps
on
to register to
issue summons on
27-4.
Not received, not returned. Not returned as yet. Hazira filed by the petitioner indicating presence in court. Yes, so Stephen signed. One. Stephen signed. Yes, stop officer indicates that service in respect of the respondent's service report not yet received. We listed after?
Let it be after 2 weeks, Your Lordship. In the meantime, we'll try to find out.
Just after 2 weeks, yes, for service report for appearance of the respondent.
7.
This is again that election matter, my lord. Here, there are about 7 respondents. Need to know some of the. I think some of the respondents are here through their counsels. Just have to find out, my lord, who are there.
Only one respondent number 4 has entered appearance. Respondent number 4 is whom?
Respondent number 1, sir. No.
Have you filed your power?
Yes.
Where is it? Have you filed your Hazira?
We have filed miscellaneous petition also
for
maintainability of the case.
You file an application, my lord, challenging, raising preliminary objection on the ground that this
it was
application
filed
is
after
beyond
45
limitation.
days, Your Lordship.
Is beyond? Is it
No,
correct?
Beyond.
There's some calculation defects on their part, my lord.
No, there.
The day on which the limitation period ended, my lord, it was a closed holiday. I mean, it was a declared holiday. So obviously, as per section 4, my lord, the day when the court reopens shall be the date on which the limitation ends, as per section 4 of the Limitation Act. So that perhaps they have.
Your Lordship, law of limitation may not be applicable in the RP Act.
Yes, may not, it is not.
Yes, it's not.
Yes.
They have filed on the 48 days.
No, they're saying they're contesting that. They say that it's within limitation. It's not a question of continuation. It's a question as to whether that election petition was filed within time as per for 5 days prescribed by the Act. That's all. The court examine only that part.
No, Your Lordship.
Yes. Even whether the petitioner presented the petition before the registry.
45 days.
Yes, within 45 days.
Yes, within 45, but they have not.
So you see. Yes, where's your miss case?
They filed this application, my lord. We have not filed any condonation application because, as per us, my lord, it is well within time. They are saying that it's beyond the limitation, my lord.
Have you filed your appearance for today?
Yes, sir.
You filed it?
We have
Okay.
filed our
You have not filed your appearance?
We have
You filed your appearance. This is okay, fine. This is Mr. CCT Sangma. Yes.
or respondent number 1, Your Lordship.
You file your appearance, or the file is being maintained now. For appearance, every particular respondent, please file a separate hazira, file it.
I will file on the course of today.
It's not course of the day, then we can't mark for your appearance. Yes, anyway, we will just to streamline the procedure. Mr. Your phone number 1.
Yeah.
This is from which constituency, Mr. Thapa?
This is with regard to Ramrai.
Mr. L. Sangma.
LM Sangma.
LM Sangma. Together with Emily has entered appearance on behalf of respondent number 1. Mr. CCT Sangma has also entered appearance on behalf of respondent number 4 and filed their powers and appearance. Stop. What about service and the others?
Well, it's very inconclusive so far as the other respondents are concerned. I'll just find out the status. Can we grant us some time?
No, because see, it says here in office note, in respect of 5, 6, and 7 has been returned due to an insufficient address. It's noted by the postal department.
Which respondent, Your Lordship?
5, 6, and 7.
5, 6, and 7. We'll take first steps in respect of them now.
Yes,
with fresh
as the notices in respect of 5, 6, and 7 have been returned unserved due to insufficient address, as noted by the postal authorities, comma, the petitioner prays bonds allowed 1 week for that 1 week's time to effect service with the correct address. Yes. On the next election petition number 223, election petition number 2. Stop. Next miss case. Mr. LM Sangma, Learned Counsel for respondent number 1, submits that the minister's application has been filed, raising the objection that the election petition has been preferred on the 46th day, which is beyond the prescribed limit of 45 days as allowed by the Act. Stop.
Presentation of People Act.
Yes, representative of the Act is naturally of the Representative People's Act. Stop. On next page. On the other hand, Mr. S. Thapa, appearing for the election petitioner, submits that there is no delay. There is no such delay, and the election petition has been filed well within time. Stop. Next paragraph is allowed. We will fix it when he prays allowed 1 week's time. We'll list out he prays for 1 week. List is matter for 1 week for hearing on the miss case. Yes. You say 46 day, 1 day delay.
Yes, Your Lordship.
8.
Obliged.
Yes. Yes.
May please Lordship. I find my power for responding number 3 and also find the Hajira Lordship.
Very good.
Yeah, Lordship, the petition is sufficient complete because the Chief Election Commission of India, returning officer and Chief Electoral Officer, they are not making the necessary party. Only the private respondent.
They're not necessary party.
I am entering appearance of respondent 1. He is the return candidate.
Very good. This is from which constituency?
Dadangri.
Dadangri. This is okay. This is on corrupt practices.
Yes.
So have you sworn the affidavit properly with regard to corrupt practices?
Yes, Your Lordship.
It's been sworn properly. Because corrupt practices is not only challenging affidavit, correct?
It's not corrupt practice, Your Lordship. It's misleading information, Your Lordship. Some information, some facts and circumstances, some facts he has not placed on record, Your Lordship.
Then we have to go through your affidavit piece by piece to see whether what are the statements you made, which is misleading, which is not, and it'll amount to corrupt practice. That means.
My lord, if I may submit.
Yes.
The first thing is if they are saying that I have suppressed information, at the end of the day, it amounts to corrupt practice. That's
Yes.
the only way I can be disqualified.
Yes.
Even otherwise, they have specifically made averments that I have run unauthorized toll gates, this and that, amounting to corrupt practices. And in such a situation, as per the conduct of election rules, a separate affidavit in Form 25 is required to be filed. It is my submission, my lord, that it has not been filed.
No, that you can raise. You can take the objections. That no, that you are free to take objections. That's only this court is inquiring that whether if you are making allegations that the election should be, that the return can be declared. I mean, the election should be declared null and void is because of corrupt practice. If it's corrupt practice, that means it needs a special affidavit.
Yes, Lord.
If it amounts to corrupt practice.
Because whatever we have stated in the petition, Your Lordship,
Fine,
we have stated that
the other petition I've just seen personally now, because the matter just started, is that it's only on affidavit and false declaration or wrong declaration, incorrect declaration, so on and so forth. That is a matter which had been looked at during scrutiny. But in this matter, if it goes beyond that with regard to corrupt practice, then you can re-examine.
Another objection which I would like to raise, my lord, which is mandatory in nature, is that the petitioner himself has never come to the court, to the registry, my lord, at the time of presentation of the plaint.
Is that correct?
Yes.
he has signed, Your Lordship.
No,
It is admitted, my lord. So matter has to be dismissed. This is I have a judgment, my lord.
Yes. The law provides like that.
It is.
When election petition is filed, he has to come himself, register and present it within 45 days.
Yes.
He has to sign every page, even the ones that issuance on notice, every page of the election he has to sign, even for the service to other side.
He has never
He has to swear each and every line of every averment that's been made. It has to be verified in a proper manner. Again, I'm repeating myself what I was saying yesterday.
My submission, my lord, is admittedly he has not come. And if this is the position, my lord, at this very threshold,
That will be then you have a written statement that will come by evidence. Then it'll be a preliminary issue.
look,
You file written statement. Then we take a preliminary issue whether the election petitioner presented the election petition, physically before the registry. Then even the registry, you have to name those witnesses, and if that's correct, that's it.
And moreover, our private respondent, there is nothing even a small whisper against the respondent number 3.
No, that is
not even
against you.
Just the performer respondent, Your Lordship.
You are number 3.
Yes, Lordship.
You're the return candidate.
No, he is the losing
Losing
candidate.
candidate.
Since the petitioner is praying that he should be elected without holding fresh by-elections, as per the law, the other candidates.
Okay. Yes. Yes. Mr. P.T. Sama for
3.
Number 1 is
Myself.
Mr. S. Deb is present on behalf of number 1, Ms. Falzira. On behalf of number 2, MSS Marpana is present. 2 and 4. On behalf of number 3, Mr. P.T. Sangma is present. Who are the others who are not served?
Only 4 respondents, Your Lordship.
That's all are served.
On one more point, Lord, if I may.
No need to make any more points. You can make all your points by parties permitted to file there. When? Written statement within, objections within 2 weeks. Yes, just thereafter. You make all the objections there. Then you file an application for taking some issue, the preliminary issue, and we'll take it up. Make the job of the court easier.
9.
Item 9, my lord, the
May it
affidavit
please, Your
is...
Lordship. Your Lordship, I pray that I may be allowed about 3 weeks' time, Your Lordship, for filing my affidavit.
Already allowed how many times?
Yes, I think this is the 3rd time, Your Lordship. Or 2nd time or 3rd time? Your Lordship.
What's the matter about?
It is
Challenge to the disciplinary inquiry.
You've been terminated?
Yes, he has been.
Then no urgency. It's on the prayer of Leonard EAG, so assisted by?
By,
Yes.
I am Lingda.
Is he on the panel also?
No, this is a private for the bank,
Oh,
Your
sorry.
Lordship.
Right, sorry. On the prayer of the learned senior counsel Ms. Diangi, assisted by so-and-so, for the 3 weeks time granted for affidavit. I thought the government matter.
10.
May I please, Your Lordship? I have received parallel command from respondent number 2, Your Lordship. So I need some time to prepare the affidavit.
What is the matter about?
It is regarding pensionary benefits, Your Lordship. Actually, he was not regularized, that's why pension was not paid. But
No, but I miss case.
Without.
What is the order in this case? What is the order to pass in this
It
case?
is implement, Your Lordship.
So what was the order passed in this case? Miss case number 31.
Lordship, here, service of notice was supposed to.
Or implement.
Implement this.
You given notice. You served them.
Entering appearance on behalf of respondent number 4, Your Lordship.
Right. Huh? Yes, Mr. K. Karmaplang has entered appearance today on behalf of someone number 4 and he prays for and allowed how much time?
3 weeks.
No, you, for you.
2 weeks time.
2 weeks time to file affidavit. Seminar prayer made by MS as per Chaji, GA. Prayers allowed just after 2 weeks. On so.
Obliged.
2 weeks or 3 weeks, yes. This court won't be here for some time. Yes.
11.
Please, Your Lordship. Your Lordship, I beg to seek 3 weeks time, Your Lordship. Your Lordship, I also.
You file affidavit?
Your Lordship, we've not filed, Your Lordship. Bring for further 2 weeks time.
But then that time he said instruction had been received. What's the matter about?
Your Lordship, it's about.
It's an interim order. That's why.
Yes, Your Lordship.
Your Lordship, further 2 weeks.
What is the matter about?
The post of assistant professor, Your Lordship.
In?
NIT.
NIT, Your Lordship. Civil engineering department.
Okay, MS, how much time further?
2 weeks.
MSS from Thao, by so and so, by Dr. Anybody praise funds allowed further 2 weeks to file affidavit. List prayers allowed. List on so and so. Interim order to continue.
I'll oblige, Your Lordship.
Next date, yes.
12.
I have filed my affidavit. There is a very small issue involved. They are asking for, my lord, opening the seal cover. But admittedly, I have enclosed all the documents. On the date of DPC, he was facing, my lord, criminal trial. So I have annexed all those things, made my statement.
But you've received a copy?
I received it today only, Your Lordship.
Whatever, Your Lordship, whenever you...
So you want to file agenda or what to do?
I will file agenda, Lordship.
Mr. S.N. Learned Counsel for the respondent, University, submits that affidavit. You filed today only, has been filed today itself. Stop. Mr. Datta, counsel for the petitioner, submits that he has just received a copy and requires time to go through the same as to whether rejoinder is necessary. This is the matter after 2 weeks. Yes. All right.
13. Your Lordship, I'm appearing on behalf of the respondents. I require further 3 weeks time, Your Lordship. We just received the parawise.
Salaries have been paid for 1 year.
Yes.
Then, how will these poor fellows survive?
I humbly pray, Lordship, at the stage of my salary be released, Lordship. In more than 1 year, Lordship.
I understand, Your Lordship. It is
See, he's been working since 2001.
And from 2022, they have not received their salary.
They have also they have recommended him for regularization 23rd June.
Your Lordship may give us 2 weeks time, Your Lordship. After that, we'll see how to go about, Your Lordship. The parawise comments was received just day before yesterday, Your Lordship.
We can see them and we can dispose it off. If parawise comments will suffice.
Then in that case, Your Lordship, may come by on Monday, Your Lordship, because I haven't gone through it also, Your Lordship.
The matter regarding salary and pension, this court very
Your Lordship.
sensitive. This is matter on Monday to enable the learned EAG to apprise the court at the exact situation of the case.
Both 13 and 14 is
Monday.
15.
Please, Your Lordship.
Yes, I must also know.
On respondents number 4 and 5. So I may be allowed to obtain a status report, Your Lordship.
No, on number 4 has been received. Number 5 has been received. Office note indicates that service on respondent number 4
May I please, Your
is
Lordship?
complete.
I need some more time to file the affidavit and for
1 second, let the yes and Officer indicates that AD card respect number 4 has been received, whereas on behalf of number 5, service reports not complete. Stop. MS Eric Khasana praised that she may allow some time to obtain the status. Stop. MS S. Matapana on behalf of the respondents number
1, 2, and 3.
1 and 2
And 3.
and 3 praised for and allowed 2 weeks time to file affidavit. This thereafter also.
Hearing. Supplementary list, item number 6.
Number 6 here then. Oh yes. Yes, my general.
These two writ petitions involves the analogous question of both of law and fact. In the first writ petition, there are 16 petitioners before your lordship.
In there are two. One is 462 and other is
462. There are 16 writ petitioners.
You take 462 first.
Yes, lordship. Then in the second writ petition, there are 38 writ petitioners. Their grievances and the relief sought are identical in nature. Your lordship, before I take to you...
First one, how many petitioners? First one?
First 16.
16 petition. And the writ petition number 2?
Writ petition number 2, there are 38 writ petitioners.
Number 2, number 1. WPC number? 483.
483. First one is 460.
38 petitioners.
Yes, lordship.
Yes.
Lordship, before I take to your lordship the factual aspect of the matter, let me brief this honorable court what is the case about. Lordship, here all these petitioners, they were appointed. Some of them, they were appointed on contract basis. Some of them, they were appointed on daily wage basis. Now, but their appointment was through an advertisement. The posts were advertised.
1 second. You mean to say there was an advertisement?
Yes, there was.
Through selection process.
Yes.
And upon this contract?
Appointed on that. That is my grievances. That is my grievances. There were posts were advertised. Applications were called. 2,000 plus applications were received by the department. Department, in order to screen out the candidate, first conducted the written test, then they conducted the oral interview, and after doing all this, they have prepared a select list by following even the reservation policy.
Okay.
And not only that, before any appointment letter was issued, police verification was also carried out. Now, these people, they continued to be employed on contract and daily wages and are being paid according to the minimum
When
wages.
were they appointed first?
Pardon?
Which year? Which year?
They were, your lordship, the first, they were appointed in...
Take place?
Lordship will find it in page...
No, just let them submit. When? Just give me the year.
Yes, lordship. They were appointed in, first batch was appointed in 2013.
Okay, first batch.
2013, 60 people were appointed.
Okay.
60 people were
Yes.
appointed, your lordship.
2013.
Yes, lordship. Now, their process of regularization was taken by the government, by the department. We were intimated, and thereafter, your lordship, instead of doing the regularization, what they have done, they have issued a letter that we all will be regularized under the RCW scheme.
How will they go to RCW scheme if it
No, that's my grievances, Your Lordship.
Okay, continue.
The state stand is this, that we will do regularization. In their affidavit, they have clearly stated, we are committed to regularize these people. But we will do under the RCW scheme. And that too we will do only for those persons who have completed 10 years of service either on contract or on daily wage basis, Your Lordship. Now, Your Lordship, so far the selection process is concerned, the state of Meghalaya has formulated the rules under Article 309. There are rules, and I will point out to Your Lordship those rules. The power is conferred under Article 309 to the state to formulate the rules with regard to the recruitment, and in pursuance to that power conferred upon the state has formulated the rules for the appointment of the class 4 employees. Those rules, Your Lordship, provides only one mode of recruitment. Only one mode. That is the recruitment by direct selection process. There is no other mode known to the rules that other than the direct recruitment. All other modes are not within the purview of the rules formulated by the government under Article 309. Now, there is no rule which says that appointment can be made through the RCW.
Yes.
There is no rule. There is no rule as such.
RCW is a scheme.
RCW is a scheme, and I'll show to Your Lordship, that scheme even is not applicable in the case of the petitioner. Even in the case of petitioner. Now, Your Lordship, I'll just first point out some the power of the state to formulate the rules is different than the power of appointment.
Yes.
Power of appointment is conferred under different article. Power to formulate the rules is under Article 309. Your Lordship will just have a look on Article 309. Lordship, subject to the provision of this Constitution, acts of the appropriate legislature may regulate the recruitment and condition of service of the person appointed to public services and posts in connection with the affair of the union or of any state, provided that it shall be competent, the rules making power is under proviso, provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affair of the union, and for the governor of a state or such person as he may direct in the case of services and post in connection with the affair of the state, to make rules regulating the recruitment and condition of service of person appointed to such service and post until provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rule so made shall have effect subject to the provision of any such act. So then, Your Lordship, this power to formulate rule is under proviso to Article 309. Now, power is exercised. I'll take to Your Lordship to what rules are formulated under this provision. Before that, I refer to Article 162, which gives the power to appoint. Power to appoint is different than the power to formulate the rules. Subject to the provision of this Constitution, the executive power of a state shall extend to the matter with respect to which the legislature of the state has power to make laws. Next, it is covered under proviso. Provided that in any matter with respect to which the legislature of a state and parliament have power to make rules, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. Meaning thereby, Your Lordship, when the rules are formulated, executive power of the state to appoint will be subject to the rules formulated by the state. In this case, Your Lordship, the state has formulated the rules. If Your Lordship take my rejoinder.
Rejoinder? We'll not even open the petition. We'll sit the rejoinder.
I'm just pointing out rules. I'll just open the petition.
Procedure for the equipment. Yes, page 21.
No, Your Lordship.
Of your
rejoinder is
page 21 of your
rules
rejoinder.
are at page 21.
Yes.
That's Lordship. Annexure 19, page 21. In exercise of the power conferred by the proviso to Article 309 of the Constitution, the Governor of Meghalaya is pleased to make the following rules regulating the recruitment and condition of service of persons appointed to the post of record supplier, daftari, jamadar, etc. and other grade 4 staff of the Meghalaya Civil Secretariat, namely. And these rules...
Now these people are in the Secretariat Administrative Branch?
Yes. They are, and the rules are applicable to these people. And the selection process is carried out in accordance with these rules. Your Lordship, see, I will just point out this definition of service at clause H. Service means the Meghalaya Civil Secretariat record supplier so-and-so service. Then Your Lordship come to Rule 3. Constitution of the service. The service shall consist of the following persons, namely A, B, C, D. My case falls under E. Persons recruited to the service in accordance with the provisions of these rules. If I am recruited in accordance with these rules, then I form a member of the service. Am I clear, Lord?
Yes.
That there is no dispute that I am not recruited in accordance with the selection process. And once I am recruited in accordance with the selection process, the day I am appointed, I become the
Regular employee.
Regular.
Because you were selected against sanction posts.
Against sanction
adjusted
posts.
Against, I'm not appointed. I mean, you were selected but adjusted against sanction posts. Is that correct?
Yes, that's correct.
Okay. Yes.
Your Lordship, then come to your Lordship, Rule 4, composition and strength of the service. And PNs falls under
Class 4 non-gazetted.
small I. Then your Lordship will come, paragraph Rule 10. What is the mode of appointment? Rule 10.
Yes.
Sweeper, cleaner, chokidar, PN, key, chokidar, watchman and malis appointment to the post of lift operator, sweepers, cleaner, chokidar, PNs. Key, chokidar, watchman and mals shall be made by direct recruitment from the list prepared by the selection committee under Rule 18. So here also in this case, a select list is prepared, and it is prepared even after following the reservation policy of the state. Then your Lordship will come to procedure. What is the procedure for direct recruitment?
Why you skip Rule 18? Rule 18 also.
Yes.
Yes, what's wrong?
I don't know.
No, he's jumping Rule 18. I said.
I'm giving for you. You are here. Conditions of eligibility. Rule 16 says, in order to be eligible to appear at the interview, candidate must satisfy the following condition, namely nationality, age, 18 years, maximum 27, and relaxable whatever is there. See, education qualification is class 3, which subsequently was amended by a notification which is annexed at class 6. I'll just give this notification. From class 3 to it is raised to.
Okay, now you have shown that these are the rules that are in place of the 309 applies to the petitioners who are in the Secretariat Administrative Branch, and so they have been selected. You said that they've gone through a due process selection. They've been appointed and accommodated against sanction posts, but in a temporary capacity.
In the temporary capacity, Your Lordship.
Continue.
In the temporary capacity.
Yeah.
And I have also pointed out that when the moment I am appointed, I become the member of the service. Then, Your Lordship, I take to Rule 22. 22.
Rule
22. Subject to the availability of permanent post, every member of the service shall be confirmed in the post to which he is appointed if he has completed at least 5 years of service to the satisfaction of the appointing authority and is otherwise considered fit for confirmation. Your Lordship, rule provides that I had to be confirmed after 5 years. Maybe it is whatever type of appointment they give. Now, they having been not done so, they have resorted to another first illegal practice they have adopted, that when the posts are permanent and sanctioned posts and selection.
Another point, are they available at a point of time? The sanctioned posts, that means confirmation be subject to availability of posts also.
Yes, posts are still available.
That has to be, that's a qualifying feature also.
Yes.
If the confirmation be to availability of posts, that means within 5 years you'll be confirmed in service subject to a post being available. Yes.
Yes.
Okay.
Lordship.
Now your stand is that when the selection was there were enough vacant
Enough
sanction posts.
vacancy.
We were never given proper appointment.
Yes.
We were just put in the temporary capacity.
But selection process was done.
Yes, no, due process.
Due process.
Against these sanction posts, suppose there are 10 sanction posts.
Yes.
You've been selected.
Yes.
But instead of being accommodated against the sanction posts and given
On
regular
the-
pay scale.
on the permanent
On a
basis.
permanent basis, of course. And be given a regular scale of pay. You were not given, you put as a contractual and daily wage.
Daily
And then
wage.
after 5 years, you should have been, if you had been regularly appointed, you've been confirmed in a post. Since the availability
Posts
of
were
post.
already there.
Okay.
Posts were
Okay,
already
continue.
there.
I'm
Your
just trying to
Lordship.
understand, I mean, what is
Yes.
the basis of your case? Shorn of all other details.
That's why, Your Lordship, I am taking the rules
Yes.
first. Rules first, so that it is slightly easier for me to place the facts in conformity with the rules.
Very good. Easier for a court to understand. Also.
Yes, Lordship.
Yes.
Now, there are two illegalities which are sought to be regularized by these two writ petitions. First irregularity committed by the state is this, that instead of giving appointment on permanent basis, they have given appointment on contractual or ad hoc basis.
Or daily wage basis.
Daily wage basis. Second irregularities which they are committed, that my source of appointment and source of recruitment is same as that of the permanent employees.
Yes.
There is no difference between the source of recruitment. Secondly, my nature of duties and responsibilities are same as that of the peons who are employed on the permanent basis. Now, when these things are equal in natures,
Yes.
I ought to be have given the at least same pay.
Yes.
Same pay, what is for, because I do the equal work
Yes.
and my source of appointment is also same.
Yes.
And that is denied to me, at least after 5 years of the confirmation. Up to 5 years, all right, they were paying me on the, but after confirmation, I become entitled. And you, otherwise also, Your Lordship, before expiry of the 5 year, state cannot discriminate so far the equal pay for equal work is concerned.
Yes.
The appointment may be either contract or ad hoc.
Yes.
But if the source of appointment, Your Lordship will have to see by what means they have come. Supposing department is having 3 categories of class 4 employees. There are class 4 employees who are recruited through direct selection process and are appointed on permanent basis. Second category is the peons who are recruited through the regular selection process but are appointed on contract or ad hoc basis. Third category is these peons recruited dehoves the rules just by recommendation of some politician or whatever, and no selection process, appointment is given. Now, what the state is doing, state is putting, see, my category of contract or ad hoc, whatever may be called, cannot be equated with those contract and ad hoc category who come through the horse the rules.
Yes.
State is treating two unequal as equal. That is a hostile discrimination under Article 14, which is not permissible. So my prayers are twofold. I am seeking regularization. Regularization of what? Regularization is to the effect that I am denied the permanent status. It's not that I am seeking that what happens sometimes, some selection process is there and something is lacking in the selection process. And therefore, person approaches the court for seeking direction, ignore that lapses and regularize. Here, what I am seeking regularization through the process of directing the state to give a permanent status. Otherwise, I am already selected through the due selection process, Your Lordship. Now, state is not denying this factual aspect that we are not appointed through the selection process. State also do not deny.
No, because your selection was pursuant to an advertisement, correct?
Advertisement.
Then how can you deny? How can you deny it?
They cannot. But
they cannot. I mean, that is a given.
No, what they are trying to do, they say that we are regularizing you, but we are regularizing you
under RCW scheme.
RCW.
Right.
Scheme.
So they can deprive you of the benefits, which is.
And the whole exercise which was done for giving me contractual or ad hoc appointment was with a view to deny me the financial benefit. They continue to do so. No, first thing they are denying. No, they have advertised. Second advertisement is done. Court has stalled. Against that because court has put a status quo order. They have started appointing people from the back door, giving them the temporary appointment. Your Lordship, this sort of practice, Your Lordship, requires a serious concern of this court, and in order to ensure that unemployed youth are not exploited in the manner in which the state is trying to do. They are class 4 employees, Your Lordship, and serving to the state at 5,000, 7,000, then increasing 13,000. This is a salary of a state. They have a family. No, also they don't see any light. State is telling go under RCW. Then again work under RCW for 10 years. Then ask for, and that is not permissible under the rule. Rule says that there is only one mode of
recruitment. Yes.
Your Lordship, I just placed the facts.
That's just the background you've given.
Yes, this is the background.
I thought you concluded the arguments.
No, because
okay.
My case is like that only.
Ingest.
Normally what happens, facts are placed first, then Your Lordship. But here, position was different, you know.
Usually, it's always the law follows the facts. But here is the facts will follow the law. Okay.
Facts doesn't follow the law.
No, out here you're taking the other way around. Usually the law follows the facts. Now the facts will follow the law. Okay. Yes.
Your Lordship.
No, let him start. It doesn't matter. Yes.
Sir?
Yes, please.
Yes, Lordship.
Just give the.
Your Lordship will just first come to my paragraph 2.2 of writ petition, page 9. Page 9. Lordship got it?
Yes.
There were initially 60 vacant sanction post of PN in Secretariat Administration Department Nazara under the government of Meghalaya Shillong during the year 2012, and the department had obtained the approval of Personnel and ARB department by their endorsement number so and so and finance concurrence dated 24/1/2011 for appointment of peon through written test and personal interview. The said posts were advertised by the department-wide advertisement number so-and-so, dated 20th January 2012. The department for the region best known to name did not advertise the post on regular basis, but the said posts were to be filled up on daily wages at the rate fixed by the government under the minimum wages. The minimum wages prescribed was not less than 18 years on 1/2/2012. The minimum qualification for the post was class 6, passed from any recognized candidate for the post were required to appear for written test and interview. Your Lordship will just see the reply of the state to this.
No, let's go to advertisement first.
Sir?
Let's see the advertisement.
Yes, Lordship. Advertisement is at page 29. Page 29. Applications are invited.
But then see, the advertisement says very clearly for temporary engagement.
Yes, Lordship.
Then?
That's what is my grievance is, that when the posts were sanctioned posts, they ought not to have been even advertised.
Yes, please continue.
Yes. Applications are invited from the citizen of India as defined in Article so-and-so for temporary engagement of peon in Meghalaya, Civil Secretariat Shillong, on payment of daily wages at rate as fixed by the state government under the Minimum Wages Act from time to time for unskilled labor, and will be received by the undersigned on or before 6/2/2012. Application should be accompanied by Treasury Shillong. Then Your Lordship, paragraph 3. Application may be submitted in the standard form as published in the last page of part 11 of the Meghalaya Gazette. Application must be accompanied by attested copies of school certificates, scheduled time. Incomplete and defective application will be summarily rejected. Age 18 years. The minimum qualification is class 6 passed from any recognized education institutions. Details of test interview will be communicated in due course of time. Pursuant to this advertisement, Your Lordship, I have stated in the petition that 2868 applications were received. 2868 applications were received, and out of these, after doing screening test, 170 were shortlisted, and after interview, the final list came of 157. Your Lordship, at page 30, the written test letters were issued, and page 31 is the interview letters. Then Your Lordship, page 32, 33 is the select list, which includes the name of 157. All the writ petitioner in both the writ petitions, names are reflected in this select list. Now, Your Lordship, the first appointment was given at page 37. Page 37 on 12th March 2013. The following persons are appointed as casual peon in Meghalaya Civil Secretariat for a period of 1 year from the date of appointment on a fixed remuneration of ₹4,000 only per month. This issue with the concurrence of Finance Department, wide ID number so-and-so, ₹4,000. Your Lordship will find here, this first batch was on contract basis for 1 year, but after expiry of 1 year, there was no written extension, and they were allowed to continue as if they are permanent. Their ACR, even ACR, they were asked to fulfill, to submit, and their progress was monitored, and CL they were getting, but save and except the pay, rest all other things they were considered at par. Then Your Lordship, in the further appointment letter which were issued say in the same month, I just read one of the appointment letter. The following persons are appointed as casual peon in Meghalaya Civil Secretariat on a fixed remuneration of so and so only per month with effect from the date of joining until further orders. These appointments, further appointment, they say further order, further orders. All these appointment letters are enclosed. Then your lordship, the case for the regularization of these persons was taken up. The Nazir of the Meghalaya Secretariat Civil Department, he has circulated a note dated 21/12/2017 to all grade 4 casual peons of the Meghalaya Secretariat Civil Secretariat. At the outset,
Where is that note?
47, page 47. Page 47, Lordship.
Yes.
To all the grade 4 casual peons of the Meghalaya Secretariat Civil Secretariat. At the outset, I take this opportunity to express my thanks and gratitude for your cooperation to the department in diligently performing your duties in the department officer where you have been posted. The department recognizes your contribution to the office of the Meghalaya Secretariat Civil as a whole. Though your appointment is temporarily casual in nature, the department is taking up the matter with the concerned authorities for regularization of your services. I would also like to state that this department is committed to revision of the remuneration as and when it is necessary for the same, while your regularization is still pending. The department has also granted 7 days casual leave, though with approval from higher authority, necessary step is be taken to increase the same to 15 days. I would also like to inform you that there have been reports made to the undersigned that there are a few staff are not performing their duty as expected, and your performance is being monitored on a regular basis. I firmly state that in case your performance is not up to the mark, your service may be reviewed and the department may be compelled to take action. Therefore, I like to urge you to continue performing duty assigned to you diligently and dedication. So, Your Lordship, this note refers that the process of regularization of these people was undertaken by the department, and information was circulated in the form of a note by the Nazir.
Mr. General, we'll just take a short recess. I have some problem with my eyes. I'm getting some aberration. We just resume after 5-10 minutes.
5 minutes.
Not done. Sorry, I'm getting this, what?
Lordship,
Shall we continue, Your Lordship?
No, because I'll tell you why I rose just to, I get this migraine attack, so when I get my eyes become blurred, I can't see anything. That's what I happened.
So, Lordship, whether we will continue or on some other day, Lordship?
No, you continue. Doesn't matter.
If Lordship is, and then we can do it on some other day also, on Monday also, no problem. We have no issue here, Lordship.
No, it's all right.
Highly. This, I was at page 47.
Yes.
This note was circulated to all the class 4 employees. Now, thereafter, Your Lordship, we have given representations to the Honorable Chief Minister, which are at page 49, Annexure 5. And typed copy is at page 54. Then, Your Lordship, the Personnel Department Under Secretary to the Government of Meghalaya has written to Under Secretary to the Government of Meghalaya, Nazareth Department, regularization of casual. With reference to the subject cited quoted above, I am directed to request you to kindly furnish this department with the latest statement of casual employees who were appointed in the year 2013, excluding those who are no longer in service due to resignation. A separate list of casual employees who have resigned may also be attached. Then, Lordship, that Annexure 7 is the reply of the Personnel Department, which is at page 60, which is impugned in these two writ petitions. It says that it is addressed to the SAD with reference to the letter on the subject quoted above. I am directed to inform you that the casual employees who were appointed on payment of daily wages may be regularized under the RCW schemes after completion of 10 years of service. That is the decision which the Personnel Department has conveyed to the concerned department on the question of the regularization. They say you can be regularized, they can be regularized under the RCW scheme. Then, Your Lordship, we have written another representation to the Honorable Chief Ministers, and the contents of this letter, Your Lordship, at the relevant time were not communicated to us. Then we have given another representation to the Honorable Chief Minister, which is as Annexure 8. Then last reminder is at page 77. Then in response to all this representation to the Honorable Chief Minister, the Chief Minister's Secretariat has written letter dated 20th/5/2022, which is Annexure 11, and that typed copy at the back page, page 80. Your Lordship, that is very clear. I can read that, page 80. Chief Minister, from the Chief Minister's Secretariat. So and so, the Under Secretary to the Government of Meghalaya Personal ARB Department to Secretariat Administrative Department, Nazareth. Prayer on matter for regularization of casual PN through test interview in Meghalaya Secretariat. With reference to this subject cited above, I am directed to forward herewith the copy of the representation dated 12/5/22 submitted by all concerned casual PNs, Meghalaya Secretariat, which is self-explanatory, with a request to kindly examine the same. This for favor of information and necessary from your end. Now, before any final decision could be taken, the department has issued the second impugned advertisement, which is at page 81, Annexure 12.
No, but one thing, Mr. General, this letter is 25/2022. Advertisement is 9th February 22.
Yes, Lordship. After this advertisement, after this post was advertised, Secretariat Department, Chief Minister's Secretariat has written to the Personal Department to examine that representation. But advertisement was already made. Applications are invited from the so-and-so. Here, Your Lordship, there are 77 number of posts of PN which are advertised.
Okay.
Now, meaning thereby, as on 9th February 2022, as many as 77 posts, regular posts are lying vacant for which the advertisement is made. The affidavit of the government does not specify the total number of the regular post. I'll just come to later when I read the affidavit. Qualification and age, etc. These are all are same. Then, Your Lordship, Chief Minister's Secretariat, White, Annexure 13, page 83, replies to all casual PNs. With reference to your petition cited above, I am directed to enclose herewith views of the personal ARB department, letter number so-and-so 5121, for favor of your kind informations. Chief Secretariat only conveyed the views of the personal ARB department, and that letter, Your Lordship, I have already read it, which says that they can be regularized under the RCW scheme, and that one is at page
60.
Yes, Lord. Then, Your Lordship, the advertisement was made. We have given two representation to the Chief Secretary to not to give effect to the advertisement. First was given by the Annexure 14, and second one was given Annexure 15. Your Lordship. The stand of the government is this, that these people that we can be regularized under the RCW scheme after completion of 10 years. My submission with regard to this is this, that RCW scheme is not at all applicable in the present case. Your Lordship, RCW scheme is enclosed by me at Annexure 16, page 93. Here, this scheme was notified on 16 September 1996, OM number so-and-so, so-and-so. The scheme shall be called the Meghalaya Regular Casual Worker Scheme, and it shall come into force on the date of its publication. It shall apply to casual worker employed in the department. Now, Your Lordship, casual worker has been defined. Casual worker means a person who by any nomenclature called is employed for doing work on a daily wage basis. Your Lordship, first my submission is this that we do not fall under this category because we are appointed through a due selection process.
Yes.
We stand on different footing. Then, Your Lordship, most important thing is this para 3 of the scheme. Your Lordship will see conferment of the status of an RCW. A casual worker who has immediately before the date of coming into force of this scheme been working as such for a continuous period of not less than 10 years may be conferred with a status of a regular casual worker from such date, not being a date earlier than the date this scheme came into force, as the appointed authority may by order specify. for calculating the period of 5 years, absence or cessation of work for the period of not more than 30 days in the year shall be reckoned as period spent in work. Your Lordship will find the para 3 says that this scheme will be applicable, the status of RCW will be conferred only in respect of those persons who were employed for a period of 10 years prior to the commencement of the scheme. And here we are appointed after the scheme came into force. So according to para 3, the scheme itself is not applicable. Even if it is assumed that it has some relevancy, the para 3 says that conferment of the status of RCW will be only available to those employees who were employed on casual
Now
basis.
the way they implemented it is different. Now even other employees who have served for more than 10 years, they are given the status also. Not necessarily that they have completed 10 years on the date when the scheme came to force.
Yes,
Yes.
that is the
That is the way they are
they are
implementing
doing
it.
it. They are doing it. They are doing it. So my submission is this, that this scheme is not at all applicable, and we do not fall under this category. Then, Your Lordship, they have filed the state has filed the affidavit. Now, the first issue which arises here, that whether the posts were sanctioned posts. First issue, Your Lordship, which arises here, whether the posts were sanctioned posts. Your Lordship, I have stated categorically in para 2.2 of my writ petition. There were initially 60 vacant sanction posts of PN in Secretariat Administrative Department under the Government of Meghalaya, Shillong during the year 2012, and the department had obtained the approval of Personnel and ARB Department by their endorsement number 87 so and so. Even endorsement number I am giving. And finance concurrence dated 24/1/2011 for appointment of
See, the
PN
only thing that goes against you is the nature of the advertisement.
Nature of advertisement.
At that point of time,
yes,
it's more than 10 years now.
Yes, because we were considered as a permanent employee, save and except for
No, the advertisement under which you were appointed, or
Yes.
applied for, specifically states
Your
that
Lordship,
this is for casual and contractual appointment.
No, Your Lordship, my submission is this: when the posts are sanctioned,
Now you have to satisfy this court
Yes.
that the very fact that the advertisement was done,
Yes.
notwithstanding the recitals or the terms of the advertisement,
Yes.
would have referred you should refer to sanctioned posts which existing at a point of time,
Yes.
and which selection was held.
Yes.
And but for the wording advertisement, they should have been accommodated against those posts. That's your right. That is your case.
Yes, Your Lordship.
Yes.
And my
If
case
I-
is also
if I
this,
correctly understand
that the state has committed illegality, which has to be rectified and regularized by issuing a writ of mandamus.
But after 10 years,
Your Lordship, there is no bar of this.
the only bar is the delay and latches, which will be that's the only thing. Now, if you're conscious of
Your
your rights,
Lordship, here, Your Lordship.
okay, I'll not say anything. Let's just start. Yes.
Yes.
Yes. Continue.
The said posts were advertised by the department. The department, for the reason best known to them, did not advertise the post on regular basis, but the said posts were to be filled up on daily basis. at the rate fixed. Your Lordship, my allegation, as I have also pointed out earlier, that this entire thing was done with a view to deprive the petitioners for the financial benefit. Otherwise, this ought not to have been done. They wanted to deprive these people and save the money for what, and divert. When the posts are sanctioned, automatically there is a budgetary provision for those things. Otherwise, post cannot be sanctioned. Budgetary provision is there, and that money, where they have diverted, we do not know. We do not know. And instead of giving us the permanent status, they have given it. They continue to do it. Your Lordship, the people before Your Lordship are only class 4 employees, peons, with a qualification of under metric. Yes, minimum qualification, I am telling. Your Lordship, what is the reply of the state respondent?
Yes, come to that. Yes, what's the reply of the state?
Sir?
What is, come to that. What do you see is wrong with the reply of the state? Yes, come to the reply of the state. What is wrong with the reply?
Yes, Lordship. First of all, Your Lordship, there is no denial, specific denial, that these posts were not sanctioned.
Okay, that's what you say. No specific denial.
There is no specific denial of the averments made by me in paragraph 2.2. What they say in paragraph 6, that with regard to the averments made in paragraph number 2.2 of the writ petition, the answering respondent states that with the appointment of various officials in different departments, the requirement of grade 4 staff to be attached to these office of the various functionaries also equally arose. The requirement of
should be arose, Your Lordship.
anyway.
Yes.
Arose. The requirement of these grade 4 staff was initially about 91. According to them, it was 91. However, since there was a restriction in creation of regular posts as such, in order to ensure smooth functioning of the offices, the department proposed the requirement to be met through casual or contractual appointment purely on daily wage basis. So, stand of the government is this, that this ad hoc nature was resorted for 2 reasons. One was urgency, and second one that there was a ban on creation of the regular post. But they do not deny that these posts were not sanctioned posts. And moreover, Your Lordship, this fact that there was a ban is disputed by me, and the state has not brought any material on record to substantiate their contention that there was a bar. There may be bar for future creation of the post, but posts which were already created, they were already there, sanctioned post. Further that, but even that further bar on the appointment, regular appointment, is not placed before this Honorable Court. Now, at one stage, at one point they are telling that there was a restriction in creation of regular post, And in the same affidavit, at para 11, your lordship will come. Paragraph 11, at para 11, the second part of para 11 at page 4 says that the answering respondent states that it is also a fact that with regard to resolve the pending regularization of the services of the employees, the answering department decided to issue advertisement only for the vacant post without accounting the post which has already been occupied. That shows we were already occupying the posts. There is a self-contradiction between paragraph 6 and paragraph 11. At one point they say that there was a ban for creation of the post. At another place they say that only that's why that the post occupied, we were occupying some posts, were not put on the advertisement. But they are not disclosing how many total number of posts. 77 they are advertised and we are holding 91 posts. And those posts, according to the state, have not been advertised.
So contention is 91 plus 77.
Yes.
Okay.
The lordship will just see, I have filed a rejoinder to this, para 5 of my rejoinder.
So shall I submit? I think 5, okay.
5. The averment and submission as made by the respondent in paragraph 6 of the affidavit in opposition are factually not correct and the same are also not sustainable. The averment of the state respondent in the paragraph under replied that since there was a restriction in creation of regular posts as such, in order to ensure smooth functioning of the offices, the department proposed the requirement to be met through casual or contractual appointment purely on a daily wage basis contradicts the averments made by the respondent in second paragraph of para 11 of the affidavit in opposition, which states that department decided to issue advertisement only for the vacant post without accounting the post which has already been occupied. This decision was duly informed through the personnel department by the secretary in charge Secretariat Administrative Department to all the employees in the department. Hence, the posts occupied by the petitioner were not put up to the advertisement. The state respondents are not acting as a model employer. Your Lordship, there are judgments which I will place that they are to act as a model employer, not like a private person.
Okay, Mr. General, any authorities?
Yes,
I
will place, Your Lordship. I will place. The state respondents are not acting as a model employer and unlighted employer. At one instance, the state respondent averred that they could not create posts for regular appointment, hence went for casual appointment. And in the other paragraph, they state that the post held occupied by the petitioner have not been advertised, which clearly indicate that the petitioner have been engaged on casual delivery against the sanctioned vacant post by following the due process of selection. That is my reply, with an ulterior motive to deprive the petitioner the benefit of equal pay for equal work. That is the whole issue, Your Lordship. Moreover, the respondents have not specifically denied that the post held by the writ petitioners were duly sanctioned posts. The petitioner were appointed on the vacant sanctioned post through the selection process as per rules formulated by the state under Article so and so. The petitioner were not given the permanent status by a state respondent with the primary object of depriving them of the status of permanent employee, inasmuch as giving of this status would have required the state respondent to pay to the petitioner at a rate higher than the one fixed under the minimum.
So you're trying to make a case of oppressive labor practice?
Yes.
By the state?
Yes, Lordship. That is also one of the allegations. Now, what is unfair trade practice, Your Lordship? Your Lordship will just see Industrial Dispute Act 1947.
Yes.
Definition portion, that is section 2, clause RA, small RA, unfair trade practice.
What's the purpose of showing this?
Showing this, Your Lordship, this is prohibited.
No, prohibited in the sense that, okay, I mean, you're going to show RA, oppressive.
RA, I'm showing Your Lordship. Unfair labor practice means any of the practice specified in the 5th schedule. Your Lordship will come to the 5th schedule. 5th schedule.
This is Industrial Disputes Act.
Yes, Lordship, but
it's not civil employment.
What is unfair trade practice?
I'll
place Your Lordship.
You mean the definition?
Yes.
Okay.
What is the unfair trade practice? Your Lordship will see item 10.
Page of the Bear Act?
5th schedule. 5th schedule, unfair, what is unfair trade practice? In the last Your Lordship of the Act, there are
Yes.
schedules. 5th schedule.
Just read it out and just say what it is.
Paragraph, item number 10.
Yes.
To employ workmen as badlis, casual or temporary, and to continue them as such for years, with the object of depriving them of the status and privilege of a permanent workman. That is, Your Lordship, prohibited. And this is what is called unfair trade practice.
Labor practice,
Labor.
not trade labor.
Practice, which also applies in this case. That you appoint a person on casual or ad hoc basis for 3 months, make him to continue to work for time.
Yes, that's in Supreme Court that says that.
Yes, Your Lordship.
Yes.
So, from the paragraph which I have read it, Your Lordship, there is ample evidence to show that these posts were sanctioned posts, but were advertised on ad hoc basis with the ulterior motive to deprive. Your Lordship will police verification is done.
See, Mr. General, the only thing that into the mind of court is the long lapse of time that's happened. Suppose at that point of time when there was a selection and the select list came out, like you said, pre-verification done, you were appointed and then accommodated against these posts. At that point of time, you should have agitated that, look,
Definitely,
that was not done. Now, come after 10 years now, it amounts to challenging the advertisement for not putting, anyway, that is the only thing. That's only that. Yes.
Another fact also, Lordship, they are the beneficiary, whether they can challenge, whether the principle of estoppel and waiver will apply to
No,
them.
it's not a question of beneficiary, it's a question of service entitlement. See, it's different. Now, with legitimate expectation, service entitlement, if they can convince the court that, satisfy the court that yes, these whatever recruitment was done was against sanctioned posts, and whether whatever it is, it was made casual or something by advertisement.
Kindly see.
But whether you can have that kind of oppressive kind of situation where you keep them against sanctioned posts for a number of years,
that we have
and
disputed
then
that these are not sanctioned posts, Your Lordship. The advertisement is very clear. There's
you have to stick to advertisement for sure, but then the
statement
court has to
made in
look
affidavit is very
behind.
clear, Your Lordship.
But the court
There is no-
has to look behind that also. We can't just even go on the face value of the advertisement. If the nature of employment is such, and now you advertise for after 10 years again for.
And now our Lordship also will kindly consider, as I have submitted, Lordship.
How many of them are there? 91 working.
91 are appointed.
They are the beneficiary of the advertisement. Whether at this stage now, Your Lordship, whether can
That's
they
the only
can't turn
case you
around,
might
Your
have.
Lordship.
That's the only
Whether
case you
they
might
can't
have.
turn around and say,
That's
no,
that's
this
the only case you might
advertisement
have. Whether at
is
this
wrong.
stage they can come and yes, okay, let him finish. Mr. General Police Authority is getting to be 1 o'clock also. Yes.
I don't think I can finish today.
You won't finish?
No, second half may be possible, but
Second half, there's a slight problem because
Let it be on Monday,
we have
Lord.
a parliamentary standing committee visiting the High Court in the afternoon, and
up to first half.
the thing is that
whatever I can.
the other matters are there also, and so we have to receive them, and I'm not feeling too well also, but then I'll have to
Let us
perform.
finish on Monday.
You continue on Monday.
Let us finish on Monday, Your Lordship.
If possible tomorrow, because Monday I have.
No, tomorrow will be possible, Mr. Gentle.
Let it be on Tuesday. If you are not free, then on Tuesday, Your Lordship.
I thought that it would be over because a service matter upgradation. I thought it would be over in 1 hour.
This is little off the track.
Yes. It's not
a
only yes.
simple-
Yeah, right. Because
simple-
it's a peculiar kind of case.
Peculiar kind of case here.
The matter hearing is inconclusive, heard in part, just on
Monday.
Monday.
Second call.
One matter Your Lordship, which my friend has come on.
Yes.
That Setia.
No, we'll do part 1 first.
Second call.
Just part 1 matters first.
Second call,
There's
item
some-
number 2.
Yes. Yes, MS Colony.
My lord, in both the cases, my lord, a report has been submitted in person to lordship's order. I have given to the court master, my lord, the original
Where's
report.
Mr. Singh?
My lord.
Oh, he's here.
Just give the copy. I've given it to court.
A copy can be supplied to us also.
So both the IO, my lord, in the respective FIR, they have submitted the charge sheet, my lord. So this case has been charge sheeted. There are 2 FIR in this matter.
Status report, at least some progress is there. Status report has been filed by the learned government advocate MSR Kohli, indicating the fact that in both the cases, charge sheets have been filed before the court of the Judicial Magistrate First Class Saura Subdivision on 10/5/2023.
That is the first FIR, my lord.
Yes. On both the both the cases, yes. The copies of the status reports are taken on record. The same copies also to be made over to the council for the. You don't have any copies anymore.
We have, my lord.
Then you kindly to the council for the petitioner. This next paragraph stuff. As the matter has been charge sheeted, it's expected that the trial will be taken up expeditiously by the concerned court. Matters is closed at this stage. Yes. What other matter?
Supplementary list.
Some mention been made some case, part heard matter.
Any mention?
No. Part heard matter is something Mr. Jindal was mentioning. He's not here.
My lord, that is item number 16 which he was referring to, Your Lordship. My lord, that is not part heard.
It's not part heard. I thought that we'd heard it on many occasions.
In fact, my lord, I have a matter which is part. Day before yesterday, Lordship has heard. I have almost completed. That is in fact in the top of the list.
No, Mr. Jindal, you're mentioning the map number 16.
Item number 16, my lord.
Yes, no, he was.
2 days late.
Yes.
He can give his convenient date, whatever suits him. Which date you can come?
After 2 weeks, my lord, I will get.
Give the date, that would be better.
You take it after 3 weeks, but this court won't be available after 2 weeks. You take a date after 3 weeks.
After 3 weeks,
Yes.
mobilize your lordship.
Okay. Mr. I'm sorry, I didn't catch your name.
A. Sattar, my lord.
Yes, it's A. Sarkar. Yes. Learned counsel for the appellant and Mr. Vicky Jindal have made a joint prayer that the matter be taken up after 3 weeks.
3 weeks, ma'am.
Yes. On so the date you can collect.
May it please your lordship. I am also seeking indulgence of your lordship in item 21, your lordship. Some other day,
Which 21?
21, your lordship. Mr. Chair.
That lordship.
That interest, payment of interest in gratuity, your
As well
lordship.
as interpretation of Rule 9 of the Meghalaya
Gratuity Act, your lordship.
pension rules.
Well, some other day, your lordship.
How will this court remember everything?
Lordship.
I like that all the advocates of the bar think that this court, all the cases are passed through that just by mentioning that with this point that I'll remember everything, all the memories just come flooding back. It doesn't happen that way.
That issue in this case, lordship.
Singing indulgence for taking up on some other day, your lordship. That is my prayer, your lordship.
So next week, lordship, because I am not getting the pension, lordship, more than 9 years, and I got the equitable, lordship. Because
Oh yes, now I remember.
Yes.
Some other day, your lordship, not that today.
You take a date from me. Yes.
Highly apply, your lordship.
Number 20,
Yes,
and
Mr.
26, 27, 28, 29, my lord. If your lordship is not sitting in the second half, my lord, he can be fixed, my lord, on some other day. Item 20, 26, 28, 29.
20, 20, 26,
25 also, my lord.
26, 25, and 29.
27, 29.
27, 28, 29. From 20 to 29.
No, my lord.
20.
No, my lord. 20, then 25 is Mr.
Then
Chandra's
20, then 25, 26%, 29. Yes, they'll give another date. I can't fix the date now. Yes.
My lord.
May it please your lordships.
Obliged.
My lord, item number 4, my lord, the supplementary list. This almost I have concluded my hearing, my lord, day before yesterday.
You try to finish it within half an hour.
Lordship will take it up today. No problem, my lord. Subject to your lordships feeling
Oh,
comfortable.
you see, as having some.
No, my lord.
I've got a migraine.
No, what I
attack.
suggest, my
That's
lord.
the only thing.
No, my lord. I'll not insist. What I suggest, because lordship is not available for some time, my lord. So either if your lordship tomorrow, I don't know if it permits, tomorrow or Monday, my lord. Since it is almost we have.
We can try tomorrow, Mr.
Tomorrow. Yes.
Mr. Chanda has some covered matter.
Covered matter, squarely covered. Squarely covered. Madam, the matters squarely covered are pending in Supreme Court, madam. Some of the matters. No, Supreme Court, my lord, so far I have come to learn, came down heavily because they have implemented this judgment. They have implemented this judgment and accepted an amendment. Same benefit.
It's only extending the same benefits to other trades.
Other statement.
Yes. Why you would not be covered then?
Initially, few trades were given by this honorable court, madam.
Right, 1998.
Then a batch of-
Now you go back to that memorandum, OM 98, right? Yes, that is the root of all the.
My lord, then a batch of petitions were decided by this single judge, my lord. Then we filed an appeal and we preferred an SLP, my lord. The SLP is pending before the Supreme Court, madam. Those are pertaining to different trades, my lord. No, all 18 technical.
In the
trades
SLP, you saying that it will not be applicable to all the trades. But then if Mr. Chanda says it's already been implemented,
already implemented. Only in some trades, madam. Some trades they have implemented, and others, my lord.
and you made him stay overnight also in Shillong. You still he came back.
No, I stayed, my lord, here.
Yes.
It is squarely covered, my lord. Squarely covered. For some more, my lord. On the other day, your lordship, Justice, Honorable Justice Dingdo also similar.
What did you cost? What did it cost on?
This matter may be discussed. I can treat.
Same
matter. Rather than cost, I can treat. Same matter. This matter.
No, then we'll have to have a hearing because he's disputing it. He's not accepting it, Mr.
My lord, 6%
Chanda.
interest is directed to be paid within 6 months. All the similarly situated employees. My lord, I have placed these judgments of the division bench. Madam, these matters can wait, my lord. Let a clarity come. My lord, I am from Supreme very Court. much hard pressed, your lordship. Very much hard pressed.
And on the other day,
What do we do? What do we do, Mr. Chanda? Because you are the thing is that
And I have-
because your submission was that it's since it'll apply to all the trades, so there's no difficulty in hearing the matter disposing of. But Dr. Mazika is resisting that.
that SLP is pending. Can that be a ground, my lord?
It can be a ground, but in the sense that if any outcome is there. How old is your petition? What's the vintage?
My lord, 19 matter, 2019 matter, my lord. And I am very much hard pressed, your lordship. Other matters have been disposed of.
We'll do it. Then we'll do a fixed matter next week, Dr. Mazika, please. You come, otherwise you depute your junior to argue it.
My lord, what is praying, my lord? The SLP, my lord. If we can wait for that.
When's SLP fixed?
My lord, I have come to learn that Supreme Court has come down heavily, so I do not know.
But it's going to close. When's the school closing? It'll close.
It's not been disposed of.
So can that be a ground, my lord?
No, can it be a ground for stay?
Cannot be a ground.
It's not a ground. I'm not saying they keep in abeyance for permanently, my lord, till the matter decided.
I don't know
But at least
how
we can wait for some
they can
time.
go to Supreme Court if it is reversed. Supreme Court came down so far, my lord, I have come to learn, came down heavily. Why say, repeatedly SLP is filed when the matter is settled, and therefore notice was issued.
Where's the order?
No, that is my oral instruction, my lord. I cannot say authenticity of this.
My lord, in fact, similar matters are pending before court number 3 also, my lord.
No, already been disposed very recently.
This is
My lord, I have brought the judgment. It was decided on 24/3/2020.
Let us see.
Similar last paragraph, your lordship. All are similar nature. Here we are claiming for Havildar. Last para, your lordship may look into. Para 37, your lordship.
Mahesh Kumar.
Which one?
This which state EME SKT signals?
They are electrician. These two technical category, electrician.
For such a long judgment for a covered case.
Same order may be passed. Same order. It is covered, and my lord, I have given a bunch of judgment where it says within 6 months, all the similarly situated, the division bench of this honorable court reacted that within 6
You
months.
all go back to that 21/22/1998, correct, Dr. Mozika?
My lord.
It comes from there. Then what remains for adjudication? That is the murder of all OMs in regard to thousands of Assam Rifles personnel in all the across the trades. Correct. Only mistake you made is that OM has specified the trades there, but you extended the benefit to other trades not including OM. That started the entire ball rolling, where all other trades who are not entitled maybe were given the benefit. So now can you deprive them? Can you discriminate against which trade?
Electrician.
He also electrician.
Both the petition. And they are higher qualified than the SS2 are. They are matriculate. They are
Okay, Mr. Chanda, I'm not feeling too well today. We will take some other day. We'll dispose it of an open court only. You have to compensate him for the trouble that he stayed back from Guwahati.
I'll do that one, unofficially. I'll do that.
Will not be order of the court, but you have to give him lunch or something. Yes. Yes. Item number.
Supplement item number 2.
Number 2, yes. Number 2, yes. Mr. M. Chanda submits that the matter is squarely covered by the. It's already squarely covered by the orders of the division bench of this court, apart from other orders passed by the coordinate benches of the court, and praise that in terms of the said orders, the incident matter which involves riflemen, they are
riflemen, electrician,
right,
and Havildar electrician.
Okay, which involves riflemen and Havildar in electrical trade, be given the same benefit. Stop. Next paragraph. Dr. N. Mozika and DSGI, however, has raised certain objections and has submitted that an SLP has also been preferred against the orders of this court, and praised that the matter the outcome be awaited before any final orders are passed. Considering the nature of the matter and the fact that repeated orders that similar orders are existing, list this matter on
Friday night.
tomorrow.
No, next Friday.
Next Friday is what date?
19. 19 or 18 or 19.
Oh.
19 my lord. Can it be 19 my lord?
That's been for 2 weeks.
After 2 weeks, yes.
My lord, can 22? 22?
Doesn't matter, you waited for so long. I'll tell you something. We can't give dates after 22 any longer. Because can't give dates, this court won't be available till after 12th of June.
22nd, my lord?
We'll give you a...
22nd?
No, they'll give you a date, yes. If you waited for so long, from 19 till now, it's not that life will be lost.
It will come on the top of it.
Okay.
Can it be part heard?
Part heard, yes.
Deeply obliged.
But there was this item number 5 in the supplementary list.
What is it?
Look, this is regarding that neighboring matter, my lord. The appointment of post of sanitary inspector, my lord.
Yes, where were you that matter?
Lord, on the other day, Lord, it was that, my lord, it is pertaining to that advertisement in the year 2007, my lord, where 6 posts were advertised.
Oh yes, 6 and 4 posts, yes. What's it for today?
Matter was heard on Friday.
Matter was heard, my lord.
Yeah, then
thereafter, my lord, the learned senior had informed this honorable court, my lord, that some development had taken place. One of the, my lord, the appointees has already
resigned. Whether it be
my
comedy against that post. If any instructions you have?
But our difficulty, the Supreme Court reasons, my lord, that vacancy arrived. Because our case is that once all the posts were filled up, all the posts were filled up, my lord.
You'll dispose it of now? You'll give a direction, let them be accommodated against that post?
Well,
it'll be a bit long anyway.
Otherwise, let it come up tomorrow, my lord. I have no issues.
Next week, my lord, Monday, Tuesday.
No, we'll dispose of it. Because the only thing is that you see, you have proceeded in the terms of the same advertisement.
Well, our basic challenge was that...
No need to, we understand. Yes, because it's still fresh. And we'll list it next week on Tuesday. Yes, for final disposal. You just mentioned the code on Tuesday. Yes?
22. Come after
22. Any other matter left?
17 my lord. 17.
22.
17 my lord, the private response number, seniority case, private response number 7 and 8. Mr. Devnath was asked to take instruction whether they have received or not.
Yes, sir, I have received the instruction.
They have received the instruction.
And I have given the copy to him also.
They have received?
They have received.
Very good then. So we'll hear that. 17 and 22 out of 4 weeks, yes.
This is the instruction to me, you receive it.
Very good. We don't. It's received.
The copy.
Not that. Mr. Devnath, item 17 submits that instructions have been received, showing that the response 7-8 have since been served. A copy of the communication indicating the same has been produced before the court. The same is taken on board, and the same is made part of the record. Yes, just after 4 weeks for final disposal. Yes, this is promotion matter.
This is
not
not the
seniority.
promotion. This is
Not
seniority.
Yes.
Obliged.
Eighteen.
Yes, 18. Yes.
Contempt Appendix 2016.
The matter which you already heard? No.
Quite some time back.
No, I don't. Where's Mr. Changraiso?
Your Lordship, my learned senior is attending one inquiry matter at Nangka.
Okay. John, as I say, not available. Yes.
After 4 weeks, 3 or 4 weeks.
They'll give the date.
That we have on Monday.
No, the date will be given by the court master. Yes. 30.
24.
Yes, Mr. Nyota.
Receive this joint request to receive the for adjournment.
Why? Tomorrow?
It's okay.
Okay, it's adjourned to so and so on the prayer of the National Council of the parties.
30. 30. Your Lordship, I'm paying for some more time in this matter, Your Lordship.
Why?
The senior conducting counsel is not available, Your Lordship. I pray that the matter may come up after.
What's the matter about?
CRP
Pata?
Your Lordship, this is civil suit was decided based on public interest. No issue was framed. Decision was not based on the issue, Lordship.
No issue was framed and decision was on no issue.
Based on no issue, Lordship. Decision was made randomly based on public interest, Lordship.
How can a suit be decided on public interest?
Because the respondents claim that the land was given by me sometime in the year 1995.
Okay, you are TN Marak.
In Marak, yes, Your Lordship.
MSTN Marak prays submits that the High Council available. We have some accommodation. This is matter and so and so. Yes. Manacho. Actually, you wanted to complete that Mr. Jindal's hearing and finish off your hearing also. But sometimes, you don't know.